Welcome to Navigating Consumer and Family Law Challenges. Insights from SoCal's trusted attorneys.
Welcome to Navigating Consumer and Family Law Challenges, insights from SoCal's trusted attorney, Amanda Hill. With focus on family law, consumer protection, and employment law, Amanda offers helpful, caring, and professional legal services and advice. I'm Zofia Morales, and today we're going to discuss custody chaos. What happens when a co-parent stops following the court order? Welcome back, Amanda. It's so nice to have you here with me today.
Hi, thanks for having me.
So let's start with brass tacks. What are our options when the co-parent repeatedly ignores a court-ordered custody or visitation schedule?
So the options can vary depending on how severe they are, what the violations are and what they are violating and what they can potentially address. So, assuming they're a valid court order and they've been filed with the court and signed by a judge, then in reality, they can be subject to criminal or civil penalties, and that is part of what when the orders are made. The judge always warns both parents about that. But from a practicality standpoint, what actually happens, that's something a little different, right? So, first and foremost, I always recommend to my clients to make sure that they keep everything in writing and keep a log of what the violations are and what specific court orders they're violating to be able to show, if necessary, and they have to go back to court, that it's become a consistent pattern, right? Some one off violation is not going to move the needle if you file a motion with the court. But if you can show a consistent pattern of violations, then that might do it, right? That might do the trick if you want to go back to court and maybe modify the current custody orders because of the issues that you're having with the other party. But of course, first you want to address it with the other side in writing what the concerns are, what you claim are the violations. And if you can't get anywhere through that process, then you very likely want to consult with an attorney to see if having an attorney try to mediate the situation could then be helpful. And then the third course of action, of course, which is when you would escalate it to filing a motion.
Well, question for you. In writing, right? So much of today's interactions are over text or email or this sort of thing. When you say in writing, is that sort of an electronic trail sufficient?
Yes, absolutely. A lot of times, though, you can do text and email, it does usually get a little convoluted. So, what I always recommend is using a parenting app. In California, specifically, the two most popular apps to use are what's called Our Family Wizard and Talking Parents. So, for example, in San Diego and in Riverside County, they actually will recommend it oftentimes and make it a court order that the parties have to communicate regarding the children using one of those parenting apps. The benefit of those apps are, unlike in a text message where you can turn off read receipt, you cannot turn off that feature, right? So there's going to
Oh,
be a log of when you've read it. And so if you've read it and you don't respond to it, you could show proof later on, if needed in court, that they're not working with you to co-parent or respond. The other benefit of using those applications is you can create different chats regarding different issues. So, for example, one chat stream can be about medical appointments, one can be about report cards, one can be about, I'm running late, stuck in traffic, right? And it creates this really clean log of the different issues going on with the kids. The other nice feature is that you can upload school schedules, changes to the parenting plan. You can give notice regarding vacation plans, holidays, things like that. Man, I feel like I'm selling these apps, but it really is beneficial for them to use it because it keeps a really clean log of what's going on. And then that can be admissible, right? It's a party admission if you are able to submit a printed out version of that to the court to show the court any co-parenting issues that you may have had with the other parent.
well, and there are always things that bug us in this world. Some things are kind of minor, some things are more serious. How does the law kind of parse out what is a minor violation versus a serious one, like withholding the child or disappearing to some country and not saying anything?
Right. That would be obviously the most extreme.
Yes.
I actually, unfortunately, spoke to somebody recently about a situation similar to that. But no, something minor like, hey, they're 15 minutes late for the past, couple weeks, that the court is going to say, okay, you get a 15-minute grace period anyways. So maybe if it becomes such a consistent thing, you talk about adjusting when drop off and pickup is, but that's not going to be something where you need to run down to the courthouse and file something, right? But then conversely, if it rises to the level where it's affecting the health and safety of the children, for example, let's say somebody gets a DUI and now there's an issue of a suspended license. Okay, that you need to go back to the drawing board. Is somebody
Yeah.
else going to need to do transportation? Are you going to be serving time? Is this an issue where for a while you're going to need to do a breathalyzer before you have your contact with your kids, right? That's going to be a more severe situation where you're going to need to address how is this going to impact the parenting plan.
Absolutely. Yeah, I have a buddy who's going through one of those. She disappeared to another country with the kids, so that was kind of top of mind.
Yeah, unfortunately, it does happen. It's not super common, right, where somebody just takes off, but it does happen. I have had conversations with people about those types of situations. And quite frankly, um, you actually end up having to get, the authorities involved, of course, with that. There are special departments and divisions in the DA's office that deal with those types of issues, passports, you got to deal with that type of thing. And it can be really difficult depending on what the relationship in the United States is like with that other country, right? Are they a party to the Hague Convention? So that's going to come into play. And so, yeah, those are pretty intense cases, but luckily I know obviously they're very intense and you hear about them, in movies or on the news, but they really are pretty rare. If you look up the statistics, because um, actually I had to deal with that on a case once. And if you look up the statistics that the government provides, the federal government provides for how often and to what countries you have those types of cases, it is pretty rare for that to happen.
So, going back to the more garden variety challenges co-parenting, what's a common example of a custody order being violated that you might want to consider taking back into the courthouse? You mentioned 15 minutes late. Well, we'll just adjust the scheduling, but what's something a little bit more serious that you would need to?
One of the issues that I have seen more recently is maybe not the schedule per se, but legal custody decision making and which parent gets to make those decisions. If you can show a consistent pattern of one parent just completely unreasonably withholding their permission to allow for certain things to happen. So, for example, vaccinations or a physical so that they can participate in sports, or not allowing them to practice certain things that they want to practice that was normal when the parties were together, like religiously or something like that,
Yeah.
right? Just out of spite, right? If you can show a consistent pattern of those types of issues, you obviously can consider going back to court and saying, you know what, I know we were sharing joint legal custody, but now I'm facing some unreasonable disagreements by the other side, right? But you do have to show that you've attempted to discuss it, and without good cause, they're not agreeing and they're causing it to impact the child or the children and their best, what's best for them, right?
Absolutely. And how does the court handle it when it comes back with something like this, where, the other parent is just not going to give permission for the after school activity or the medical exam or whatever it is?
So I would say extracurriculars is a kind of in a different bucket, that courts don't really see that as like a huge issue unless, for example, they're in high school and they're on the verge of getting a scholarship. Maybe that would be held to a different standard. Again, I've actually seen that happen before with a client and a baseball scholarship, kind of at issue. But I also, on the flip side, let's say it is vaccinations and let's say the children need it to go to school or re-enroll in school. And now the other side is withholding because he wants to put forth this narrative that I think I want the children to go to private school or be homeschooled, whatever the underlying issues are, right? If you can show proof that the pattern and practice when the parties were together as co-parents before they separated was something completely different, and that you could show that this is now a new issue that they're bringing up, then, I think the courts usually land on, hey, I need to go back to what was the status quo for these children? Because they're already going through a lot, having their parents separate, right? So I'm going to try to keep status quo as close as possible to what it was. So they'll go back and look at historically what was happening with the children.
So, can a parent request an emergency change or some kind of enforcement if they're running into one of these issues where their rights are being blocked?
So, on an emergency basis, at least in Southern California and the jurisdictions where we normally practice, it's very difficult to get an emergency order related to that. However, you can put the issue before the court and ask for what's called an order shortening time, or an OST, so
Mm.
that the court can put it on an expedited calendar to get the earliest date possible to address those issues. Now, if, for example, the issue is related to the parenting plan, and let's say one parent is withholding the child, or maybe sometimes you'll see where one parent lives in one state and the other lives in the other, and now they're supposed to come back by a date certain and they're just not returning the child, then you can usually go in on an ex parte basis and get a court order that says they need to cooperate or else law enforcement will get involved.
Very good. And what kind of documentation should a parent keep in order to enforce or modify custody orders?
So we talked about a little bit earlier, right? Keeping everything documented in writing, using either the parenting app, text messages, the logs of the visitation plan. So if one of the allegations is one parent is not, they're forfeiting their visitation rights, they're not consistent in exercising their visitation, you want to have a written out contemporaneous log so that you could provide that to the court, or a calendar showing which days they've come and which days they haven't shown up. If there's any issues of neglect, you want to show medical records, right? Or to prove that you're the parent that's always stepped up and taken the children to all the appointments. Also, anything as it relates to social media, right? If there's any posts that are not aligning with what he or she is claiming, right? You'd be surprised someone says, "Oh, I'm so sick," or "I got stuck in traffic," or "I got a flat tire." And then half hour
They're
later,
at the bar.
they're at the bar, right? Or they're out somewhere else, or they're taking a trip or traveling. So, sometimes people don't follow each other once they break up, but sometimes they have friends of friends that send them stuff, right?
Yes.
So if you can get that, that can sometimes potentially be helpful depending on what the issue is that you're trying to prove to the court.
Now, I know a lot of times by the time you've gotten to this stage, you're pretty sick of, my apologies, courts and lawyers and all the things. Is mediation ever a useful thing in these situations, or do you always have to go back to like court intervention?
No, you definitely can do mediation. I think there is a misnomer regarding what mediation looks like in family court, especially in Southern California. So the way it works is, if you're going to do mediation, you have to file a motion to trigger mediation. So you
Oh,
have to put the issues before the court. If you want to get a court appointed mediation appointment, right? However, you can always mediate outside of court. Really, it's such a broad definition of mediation. Mediation just means you're mediating to try to settle instead of litigating in court. So you can also always do that outside of court, but you always want to make sure it's actually an enforceable agreement, right? So you need to make sure that an attorney's reviewing it, and that it aligns with what the laws are, and that it also aligns with what the goals are and the agreements of the parties. And then it has to be filed with the court. I don't know how many times people have come to me and said, "But we had an agreement and we even got it notarized." And my favorite thing is, great, but you didn't file it with the court and it didn't become a court order. So it really doesn't hold any water.
yeah. Oh my goodness. Yeah. Don't miss that last step.
Yes, and you don't have to see a judge. It's just that it needs to be submitted to the court so a judge can review it, sign it, and make it a formal court order. But until it's a formal court order, there's nothing to enforce. So if there's any violations of it, peace officers can't come and enforce it for you.
Yeah. It's worth the paper it's written on, and that's about it.
Exactly. Correct.
Okay. Awesome. That's a good thing to know, and a step you don't want to skip for sure.
Right. Definitely.
So, what is your advice for parents trying to protect their kids and stay calm during ongoing custody chaos?
One thing is to give yourself grace. I often say that to a lot of my clients, right? Is to take time for yourself, practice self care, give yourself grace because nobody's going to be perfect. Nobody's going to always stay calm all the time. But taking a beat, take a pause, take a break. That's why it's so nice to use a parenting app because a lot of times what the court will say is you have to respond within 24 to 48 hours. Great. So you can read it and then you can think about how you want to respond and go back to it later. The worst thing you can do is become a paper tiger, right? And just go back and forth, and you're going to get nowhere. The other thing I would say is to always make sure that you think before you write it and just remember that at some point a judge could be reading that. And so before you type it out and you start name calling or, criticizing the other parents' parenting skills or the way that they parent, think about it before you actually write it and think about whether it's even necessary. A lot of times I'll read messages and clients will ask for feedback on, hey, do you think I handled this conversation correctly?
Yeah.
And sometimes I'll give them advice and say, I think you could have even not responded to that one. Sometimes silence speaks volumes, right? You
Yeah.
can acknowledge it. You can say understood or okay, but it doesn't need to be a constant back and forth because that's just sometimes going to further, exasperate the issue when it's not necessary.
Yeah, oh, absolutely. I've been reading a book from a former hostage negotiator. There's your negotiator right there. And one of the things that he says is the first thing you need to do is step back from your own emotional response.
Yes. Is it Chris Voss?
Yes,
Yes, yes, I've read that book too. Yes, I actually saw him. He was a speaker at a conference I went to. It's really fascinating.
it
Yeah.
is, isn't it? Oh my goodness. So yeah, I think that's amazing advice. You know, there are some things that are red herrings that you just leave them be. That's
Exactly.
not
Yeah.
worth it. I like that. So, what would be your final words of wisdom for a parent who's going through some custody chaos and trying to settle things down?
I think the biggest overarching tip that I can give is to always put the children first. I know that sounds so simple, but sometimes, even without thinking about it, but subconsciously, there's still that animosity there. And so things get heated or they become a bigger issue than necessary. And so, if you can really take a step back and think about how is this going to impact my child or children? Is it necessary that I really battle this out, or is this something I can maybe go back to later? And or is this something that, what, in their household that's what they do, in my household that's what I do, and that's okay as long as they have two loving parents.
Yeah. Oh, that's beautiful. It's always good to refocus on what's truly important in the situation.
Yeah, absolutely.
All right. Well, thank you for sharing your wisdom today, Amanda. That has been very helpful. Thank you for joining us on Navigating Consumer and Family Law Challenges. Insights from SoCal's trusted attorney, Amanda Hill. To connect with her or her firm, visit kandhlawgroup.com and make sure to like, subscribe, and leave a review. And if it was helpful to you, share it with someone you care about.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.